For 4 years, she had been filing code complaints against my cabin with the Cock County Building Department. 11 complaints, all dismissed. All dismissed by the same office that had reviewed her own permits. Her name was Madeline Sheffield Hatch, HOA Board President of Mountain Vista Estates, Tennessee, 43, polished, blonde. Certain her one-page complaint forms outranked 440,000 cubic feet of hand-hewn timber I had personally permitted in 2008. Mine is Easton Whitlow. I am the Cock County Senior Building Inspector. The week she filed an actual civil lawsuit demanding court-ordered modification of my cabin, I assigned the inspection to my deputy. The deputy filed the cleanest compliance report he had ever signed. Then I walked her property. 41 unpermitted modifications, including the electrical bypass her husband had installed. What would you do if the HOA Karen had been suing the man who reviewed her permits? Where are you watching from tonight? Stay with me. I grew up on Stinking Creek Road in Cock County, Tennessee, 3 miles east of Newport, in the foothills of the Great Smoky Mountains. My great-grandfather Talbot Whitlow bought the original 40 acres in 1903. He had been a Tennessee Valley timber cruiser before he came home to run a small cattle and timber operation. He built the original farmhouse in 1905. He logged the upper 20 acres for himself across the 1910s, ran cattle on the lower bottom through the Depression, and held the land together when neighboring families sold out across the dust years of the 1930s. His son, my grandfather Reuben Whitlow, sold off the lower 20 acres in 1959 to pay for my father's college education at the University of Tennessee in Knoxville. My father, Thaddeus Whitlow, became a Cock County math teacher for 34 years and a deacon at the Stinking Creek Methodist Church for 28. He died of pancreatic cancer in 2003 when I was 32. My mother, Lurleen, passed in 2006. The remaining 20 acres of the original Whitlow holdings came to me by my father's will, less the small 5-acre family cemetery parcel that went to my older brother Owen Whitlow, who lives outside Nashville and runs a small printing business. I was born in the upstairs east bedroom of the 1905 farmhouse in November of 1971. I grew up watching my grandfather and my father work the land. I went to the University of Tennessee in Knoxville from 1989 to 1993. I studied civil engineering. I worked for a Knoxville commercial construction firm called Pemberton Bouchard Construction for 8 years after graduation. I passed the Tennessee International Code Council Residential Building Inspector certification in 2001. I joined the Cock County Building Department in 2003, 3 months after my father's funeral. I have been with the department for 23 years. I was promoted to Senior Building Inspector in 2008. I have held the senior position for 18 years. Halsey Brewster is 48. He has been with the Cock County Building Department for 13 years. He came on as a junior inspector in 2012 after 14 years as a residential general contractor in nearby Sevierville. He took his International Code Council certification in 2014. He took over as Deputy Senior Inspector in 2018 when my prior deputy retired. Halsey is, by every observable measure of his work, the most careful field inspector I have ever supervised. He measures everything twice. He photographs everything from 3 angles. He cross-references every code citation against the most current International Residential Code edition. He carries a binder of code amendments specific to East Tennessee in his truck. He has a quiet sense of humor that surfaces at most twice a month at the Monday morning processing meeting. He attends the Stinking Creek Methodist Church, where my late father had been a deacon. He sat in my father's pew at my father's funeral in 2003. He has been, for 13 years, the person in my office I would trust most with a case that could end my career if it went badly. He is, by my standing private assessment, the right person to take over the senior position whenever I retire. Halsey does not know this. I have not told him. I will tell him when the time comes. The Cock County Building Department is small. The department has 3 building inspectors covering the entire county, myself as senior inspector, my deputy Halsey Brewster, and a junior inspector named Quincy Eastman, who came on staff in 2019. We review approximately 800 residential building permits a year, and another 240 commercial permits. We conduct approximately 2,200 inspections a year across new construction, renovation, and code enforcement. We administer the Cock County adoption of the 2018 International Residential Code and the 2018 International Building Code with Tennessee-specific amendments. The department is housed on the second floor of the Cocke County Courthouse in downtown Newport. My office is the third door on the right past the elevator. The office has my engineering degree from UT Knoxville on the wall, my International Code Council senior certification, 3 photographs of my grandfather, Talbot, on Stinking Creek Road in the 1940s, and a small framed copy of the 1903 deed for the original Whitlow 40 acres. My cabin sits on 3.5 acres of the 20 I inherited from my father. The cabin was the culmination of a project I had been planning since I was 12. My grandfather Reuben had taught me traditional Appalachian log cabin construction across the summers of 1983 through 1985. He had been a hand-hewn timber frame builder in his younger years. He had taught me to select white oak, to score and chisel a half-dovetail notch by hand, to lay a stone foundation by sight along a bubble level. I had taught myself the modern engineering side at the University of Tennessee. I had spent 15 years after his death gathering the materials, felling white oak in winter when the sap was low, curing the timber under cover for 3 years, quarrying river stone from a creek bed on the back 5 acres, salvaging hand-forged iron hardware from a Cosby antique barn that was being dismantled in 2006. I broke ground on the cabin in March of 2008. I completed construction in November of 2009. I pulled my own permits. I have copies of all 11 separate inspection sign-offs in a fireproof safe in the cabin office. The cabin is a 32 by 28 foot 1.5-story, half-dovetail log cabin with a wide central stone fireplace, a hand-hewn loft, a metal standing seam roof at a steep 12/12 pitch to shed the Cocke County winter snow load, and a wraparound porch on 3 sides. The cabin is, by every measure, the Tennessee International Code Council uses to assess residential construction, an exemplary piece of work. The cabin is also, by my own quiet assessment after 18 years of inspecting other people's construction, the best piece of work I have ever made. I divorced my first wife, Linnea, in 2017 after 14 years of marriage. The divorce was the polite kind that small-town divorces sometimes are. No fault, no acrimony, no public ugliness. Linnea moved to Nashville to live closer to her sister. She is a probation officer for the Tennessee Department of Correction in Davidson County. We exchange Christmas cards. We share a son. Our son, Harlan Whitlow, was born in 2001. He is 24. He started his undergraduate degree at the University of Tennessee in 2023 after working at the cabin with me for 4 years as a young carpenter. He is studying construction management. He plans to become a residential building inspector after he graduates. He has applied for a summer internship in my office for the upcoming summer. The department's hiring committee will make the decision without me. I will recuse myself from any consideration of my own son's application. I have already written the recusal letter and filed it with the county HR director. The letter is in my personnel file. The personnel file is reviewed annually. I live alone in the cabin. I drive my Cocke County Building Department issued pickup, an unmarked white Ford F-150 with a small county government license plate, to and from the courthouse 5 days a week. I keep my official credentials in the truck console. I keep my International Code Council certification in a leather case in the inside left pocket of my work jacket. I dress in business casual for office work and field clothes for site inspections. I am, by every observable feature of my daily life, a quiet, middle-aged Tennessee professional. The only outward sign that I am a county official is the small Cocke County Building Department logo on the side of the F-150, which is approximately 4 inches in diameter and is not particularly visible from the road. Mountain Vista Estates was built across our south fence line in 2017 on what had been the back 40 of a Cocke County dairy operation, a Knoxville developer named Crowfoot Bridger Holdings, purchased in 2015. The development is 38 homes on lots between 1/2 and 2 acres around a small community pavilion and a stocked fishing pond. The development was marketed primarily to Knoxville commuters and Tennessee retirees from out of state. The homes range in price from $890,000 to $1.7 million. The development has a clearly defined HOA with 32 pages of bylaws and a small monthly dues structure. The HOA has, since 2017, been a generally polite organization. Madeline Sheffield Hatch and her husband Donovan Hatch moved into Lot 8, a 1,200-square-foot custom log home built by a regional vendor in 2018. In the spring of 2020, they had paid $1.3 million cash. Donovan was a regional commercial banking executive at a Knoxville-based bank that managed approximately $3 billion in business loans across East Tennessee. Madeline had been a Knoxville commercial real estate marketing director for 12 years. She had quit the marketing job within 6 weeks of moving to Cocke County. She had told her new HOA neighbors that she was focusing on community leadership and quality lifestyle pursuits. She drove a white Range Rover Sport. She wore Lululemon to the Newport Walmart. She referred to Cocke County, in conversations with her sister in Atlanta, documented in federal phone subpoenas 18 months later, as the Woods. She got herself elected HOA board president in October of 2022 by a vote of 27-9. She had run on a platform of elevating Mountain Vista's aesthetic standards. She had won because the previous president, a 65-year-old retired UT Knoxville accounting professor named Aldina Halverson, had decided to step down after 7 years on the board. Aldina had not endorsed Madeline. Aldina had told her husband Magnus, by Magnus's later quiet account at the cabinet hearing, "She is going to be a disaster. I do not have the energy to oppose her. Someone will have to stop her later." Aldina had been right on the first count. Someone, me, would, by the spring of 2024, stop her on the second. I want to describe the office routine, because the routine is the structural backbone of the rest of this story. The Cocke County Building Department processes its complaint queue every Monday morning at 9 a.m. The processing meeting runs 45 minutes. Halsey, Quincy, and I sit at the conference table on the second floor. Each of us has the same printed weekly complaint summary in front of us. We assign complaints to specific inspectors based on geographic district, complaint type, and existing caseload. We discuss any complaint that requires field investigation. We approve a written disposition for any complaint that can be resolved on the papers. The Monday morning processing meeting has been the same Monday morning processing meeting since I joined the department in 2003. The meeting is conducted in plain Tennessee professional language. The meeting is documented in formal meeting minutes filed with the county HR office. The meeting is, by my own quiet bragging, the most boring 45 minutes of any week in any small-town county building department in East Tennessee. The meeting is also the absolute foundation of the careful work this office does for the 86,000 residents of Cocke County. I have not, in 23 years, missed a Monday processing meeting. I will not, until the day I retire, miss one. Madeline filed her first code complaint against my cabin with the Cocke County Building Department on the 11th of June, 2020. The complaint alleged that the non-conforming roof pitch of the cabin at 1187 Stinking Creek Road creates a visual disturbance to the South Row properties of Mountain Vista Estates. The complaint was filed through the county's public-facing online complaint portal. The complaint was routed, by the department's standard automated processing, to the senior building inspector for review and disposition. The senior building inspector was me. I read the complaint at my desk on the morning of the 12th. I dismissed it that same morning with a one-paragraph written disposition citing International Residential Code Table R301.2, which expressly permits steep pitch roof construction in the Tennessee snow load zone, and the originally permitted construction documents for the cabin, filed in 2008 under permit number 2008-Whitlow-014. The disposition was filed under the standard county dismissal by merit protocol. The disposition was emailed to the complainant per standard procedure. The complainant, Madeline Sheffield Hatch, received the dismissal at her registered email address at 2:47 p.m. on the 12th of June. The dismissal letter was signed in my standard professional signature, Easton Whitlow, Senior Building Inspector, Cocke County, Tennessee. She did not read the signature, or she read it and did not connect the name to the cabin owner who was, by then, the subject of her complaint. The county does not list residential property owner names on its public building permit database, only addresses, parcel numbers, and permit holder licensing data. My cabin appears in the public database as 1187 Stinking Creek Road, permit 2008-014, issued to Self-Builder Residential, active. Madeline, by her own later account at the depositions, had never looked up the cabin's permit history. She had assumed, on the basis of her own visual aesthetic, that the cabin must be non-conforming. She had filed the complaint on that assumption. She had not, by my own running observational record over the next 4 years, ever connected the dismissal she had received in June 2020 with the county official who had written it. She had simply assumed the county bureaucrat at the other end of her complaint was incompetent. She filed her second complaint in September of 2020. The complaint alleged that the cabin's wood stove was operating without a proper chimney permit. It was operating with a proper chimney permit. The chimney permit number was on file in the same database she had not bothered to consult. I dismissed the complaint with a copy of the chimney inspection report from 2009. The inspection had been performed by my own predecessor, a senior inspector named Otis Linkletter, who had retired in 2007 and signed off as exemplary. I framed the dismissal disposition next to the framed 2008 permit on my cabin office wall. I have a small library of frames at this point. I have thought, since the case closed, about why I never said anything to Madeline across the 4 years of complaints. The honest answer is partly professional and partly personal. The professional answer is that the Tennessee International Code Council's professional standards are unambiguous. An inspector administers the code without regard to who is filing the complaint, and any personal communication with a complainant about her complaints would be considered an inappropriate conflict of interest. The personal answer is harder. I had, by 2022, come to view the 11 complaints as a small, ongoing experiment in patience. I had spent 46 years in Cocke County learning to administer rural courtesy in the face of urban frustration. I had decided that the best response to Madeline's escalating complaints was to handle them more carefully each time. I had decided that the inspector's signature on the dismissal letter was its own quiet teaching tool. I had assumed, at some point across the 4 years, that she would eventually read the signature and connect the dots. She had never read the signature. The teaching tool had failed. The lawsuit had become necessary. She filed her third complaint in March of 2021, then a fourth in August of 2021, then a fifth in February of 2022, then a sixth in October of 2022. Across the period from June of 2020 through March of 2024, she filed 11 separate code complaints against my cabin with the Cocke County Building Department. I dismissed every one. I dismissed each with a written disposition citing the applicable building code section and the original cabin permit file. I sent each dismissal to her registered email address. I signed each with my full official signature. She did not read the signatures. She read the dismissals. She did not, in any of the 11 correspondences, identify the inspector. The inspector was, by her unspoken assumption, an undifferentiated county functionary. I had not, in the 4 years across her 11 complaints, ever raised the issue with her directly. I had decided early in 2021 that the most professional course of action was to administer the cabin complaints exactly as I would administer any other county code complaint, neutrally, by the code, with proper disposition. The Tennessee International Code Council's professional standards require an inspector to administer the code, regardless of the property owner involved, including the inspector himself. I had filed a recusal notice with the Cocke County HR Director in July of 2021, covering any administrative or enforcement action against my own property. The recusal notice authorized my deputy, Halsey Brewster, to handle any future complex matter that required field investigation. The complaints Madeline filed across the 4 years were straightforward dismissal on the papers matters that did not require my deputy's involvement. I handled them myself, properly, under the recusal framework, which permitted desk dismissal of complaints lacking any factual or technical merit. I logged each handling in the county complaint database with full transparency. Any future state or federal audit of my office would find a complete record of careful, by-the-book, recused administration. Madeline filed her first civil lawsuit against my cabin on the 18th of March, 2024. The lawsuit was filed in Cocke County Circuit Court. The lawsuit alleged, in 17 pages of pleading, that the cabin at 1187 Stinking Creek Road constituted a public nuisance under Tennessee Code Annotated, Section 29-3-101, and demanded court-ordered modification of the structure to conform with current Cocke County aesthetic and safety standards. The lawsuit named me personally as defendant. The lawsuit listed my address as 1187 Stinking Creek Road. The lawsuit did not list my profession. The lawsuit had been drafted by a Knoxville civil litigation firm Madeline had retained for an initial retainer of $15,000. The Knoxville firm, a regional outfit called Lockhart Penrose Stratton, no relation to the various Lockharts and Penroses across my prior records, just a coincidence of regional surnames, had performed a basic title search on the property and a basic permit search through the county's online database. The title search had confirmed I was the owner. The permit search had confirmed the cabin had a valid 2008 permit. Neither search had identified my profession. Neither search had connected my name to the senior inspector's signature on Madeline's 11 dismissals. I was served with the lawsuit at the cabin on the morning of the 22nd of March. The server was a Cocke County deputy sheriff named Wendell Brewster. Yes, Halsey Brewster's older brother, a coincidence that would matter later. Wendell drove up the long gravel road to the cabin in his marked cruiser. He stepped out. He read the summons aloud. He handed me the papers. He looked at me. He said, in his slow East Tennessee drawl, "Easton, you realize who is suing you?" I told him I knew. He said, "You want me to call the courthouse?" I told him no. I told him I would handle it personally and through my recusal framework. He said, "You want my brother on this?" I told him yes. I told him I would call Halsey from the office on Monday morning. Wendell nodded slow. He drove back down the gravel road. I made a fresh pot of coffee. I sat on the front porch for 2 hours. I read the lawsuit 3 times. I called my son Harlan that evening. Harlan was a UT Knoxville freshman studying construction management. He had spent every summer since age 15 working on cabin maintenance and inspection paperwork with me. He knew the cabin file inside and out. He knew the Cocke County complaint database inside and out. He had, by my count, accompanied me on approximately 60 residential inspections across the previous 4 summers as part of his pre-internship learning. He answered the phone on the second ring. I told him in 7 minutes. He said, "Dad, I am driving home this weekend. I will help you build the response. Mom does not need to know about this until we have the response filed. I will see you Friday night." I told him I would have dinner ready. He drove home from Knoxville on Friday night. We worked at the cabin kitchen table from 8 p.m. Friday until 2 a.m. Saturday. We pulled every Cocke County permit issued to the Mountain Vista Estates HOA and to the individual property at Lot 8 across the previous 7 years. We pulled every modification permit filed on Lot 8. We pulled every contractor registration record for any work performed on Lot 8. We pulled every emergency service call dispatched to Lot 8. We pulled every neighbor complaint filed against Lot 8 by any other Mountain Vista resident. We pulled the Mountain Vista Estates HOA's financial records, which Tennessee Common Interest Community Law made available to any adjoining property owner with standing. We pulled the public corporate filings of Crowfoot Bridger Holdings, the original developer. We pulled the East Tennessee commercial banking records for Donovan Hatch's bank, available to a limited extent through Tennessee State commercial registration filings. By 2 a.m. Saturday morning, the kitchen table was covered in 87 separate documents. By 6 a.m. Saturday morning, after 4 hours of sleep, we had a pattern. The pattern was 41 unpermitted modifications across Lot 8 between 2018 and 2024. The modifications included a 400-square-foot deck expansion, no permit. A complete bathroom renovation with new plumbing and new electrical, no permit. A basement wet bar with new plumbing, no permit. A converted bedroom with non-conforming egress window dimensions, no permit and no compliance with the International Residential Code section R310. A backyard tool shed of 280 square feet, no permit and exceeding the under 200 square foot small structure exemption. An exterior recreational structure described in HOA newsletters as a wine cellar, no permit, and most seriously, a basement electrical bypass that Donovan Hatch had installed himself across the home's main service panel to power a third sub-panel he had added for a workshop. The bypass was unpermitted. The bypass had also been installed by someone with no Tennessee electrical contractor license. The bypass, on visual inspection by my own deputy Halsey Brewster 4 weeks later, would be classified as a serious life safety code violation under National Electrical Code Article 230. The pattern across the 41 modifications was clear. Donovan and Madeline had spent 6 years renovating and expanding Lot 8 without ever pulling a single building permit. They had performed work that, in aggregate, exceeded $340,000 in unpermitted construction value. They had performed work that violated the building code, the electrical code, the plumbing code, and Cook County building permit law. They had also, by Donovan's bank licensing records, cross-referenced with the work performed, used a commercial trade contractor named Cassius Lockhart on at least 3 of the major projects without proper county notification. Cassius Lockhart was the brother-in-law of one of Donovan's senior bank executives. The records suggested, though did not prove until later federal investigation, that Donovan had been paying Cassius in cash from a small Cayman account Donovan had set up under his own business consulting, LLC. Across the weekend, Harlan and I also reviewed every one of the 11 prior complaints Madeline had filed against my cabin. Harlan had not known about the complaints. I had not, until that weekend, told my own son that his future internship office had been quietly receiving and dismissing nuisance complaints about his father's cabin for 4 years. Harlan read each dismissal. He read each complaint. He read each official disposition I had signed. He looked up at me at midnight on Saturday and said, in his quiet UT Knoxville voice, "Dad, you did this exactly right for 4 years. Every single one. You followed the recusal procedure. You handled each complaint by the code. You did not say a word. You did not retaliate. You did not even tell me. Dad, this is the most patient thing I have ever heard of anyone doing in any building department in this state." I told him patience was the only honest currency a building inspector ever had. He had nodded slow. He had said, "Dad, I'm going to be a building inspector, just like you. I have decided this weekend." I had not told him that the decision had been on my mind since he was 4. I had let him own the decision himself. He had earned the right. I called Halsey Brewster at the courthouse on Monday morning at 8 a.m. I told him I needed a deputy inspection on my own cabin. I told him I needed it on Tuesday. I told him to walk every code section and document everything. He said, "Easton, I have been waiting 4 years for you to ask me to do this." He drove up to the cabin Tuesday morning at 9. He spent 6 hours on the property. He measured every joist. He tested every electrical outlet. He documented every plumbing fixture. He inspected the roof pitch, the chimney, the foundation, the loft framing, the standing seam metal roof, the wraparound porch, the wood stove installation, and the basement. He filed his official report by close of business Thursday. The report ran 28 pages. The report concluded, in his careful Tennessee inspector's prose, "Property at 1187 Stinking Creek Road is found in full compliance with all applicable Cook County and Tennessee building codes. Construction quality exceeds minimum code requirements in multiple categories. Inspector recommends formal county recognition of exemplary self-built residential construction." Halsey filed the report through the standard departmental review process. The report became, on Friday afternoon, the official compliance record for the cabin. On Monday morning the following week, in my role as senior building inspector and acting strictly within my regular departmental responsibilities, I opened a new complaint file on the property at Lot 8 of Mountain Vista Estates. The complaint had been filed by a Cook County resident, exercising their right to submit a complaint about a neighboring property. The complainant was a citizen named Harlan Whitlow. Harlan had filed the complaint by walking into the building department office on Friday afternoon and signing the standard form himself. The complaint listed 23 of the 41 unpermitted modifications. The complaint requested formal county code enforcement action. The complaint was routed, by departmental procedure, to my deputy Halsey Brewster for handling, because I had filed an immediate written recusal on the matter on Friday afternoon, citing the active civil litigation. The recusal was filed with the county HR director and the county attorney's office for full transparency. Halsey opened the formal Lot 8 inspection on Wednesday morning. He served the homeowners with a county standard inspection notice on Tuesday afternoon. Madeline refused to allow Halsey access. Halsey returned Wednesday morning with a Cook County Circuit Court inspection warrant signed by Judge Cornelia Trask. Yes, the same name as the Indiana Mill historian's judge, just a coincidence of judicial surnames across regions. Madeline and Donovan were not at home. Halsey conducted the inspection under the warrant. He spent 11 hours on the property across Wednesday and Thursday. He photographed every unpermitted modification. He measured every code violation. He cataloged the electrical bypass with great care. He filed his inspection report on Friday morning. The report ran 41 pages. The report cataloged 41 separate violations of the Cock County Building Code. The violations ranged from minor, the under 200 square foot tool shed was actually 280 square feet and exceeded the exemption by 80 square feet, to serious. The electrical bypass installed by Donovan was an immediate life safety violation that, if not corrected within 30 days, would require county-ordered electrical service disconnection. The total estimated cost of bringing Lot 8 into code compliance was, by Halsey's careful assessment, $248,000. The cumulative county fines available for the documented violations totaled $86,000. The state-level licensing exposure on the unpermitted commercial contractor Cassius Lockhart added another $40,000 exposure, and the federal exposure on Donovan's payment system to Cassius, which I referred to the U.S. Attorney's Office for the Eastern District of Tennessee on Friday afternoon, opened a separate federal mail fraud investigation that would eventually run for 8 months and result in Donovan's indictment in November. The morning of the hearing, the 11th of April, Madeline arrived at the Cock County Courthouse in a navy pantsuit and Christian Louboutin shoes. She had her Knoxville attorney beside her. She had Donovan beside her. She had 2 HOA board members in matching down jackets. She had, by my own observation from the third-floor inspector's office, where I was filing routine reports while waiting for the hearing, the polite, confident posture of a Knoxville commercial real estate marketing director arriving for what she expected to be a perfunctory pre-trial conference. I dressed for the hearing in my standard inspector's clothes: dress shirt, tie, brown leather work boots, the Cock County Building Department lapel pin clipped to the inside left collar of my jacket, where it was not normally visible. I carried my International Code Council Senior Certification card in my breast pocket. I had not, by my deliberate choice, worn anything that would identify my profession to Madeline before the hearing began. The reveal would, by the careful design Harlan and I had built across the weekend, happen in the courtroom in front of Judge Trask. The reveal would be on the record. The reveal would be permanent. I walked into courtroom 2 at 9:52. I sat at the defendant's table. My counsel, a careful Newport civil defense attorney named Tobias Halverson, no relation to the Aldina the retired professor, a coincidence, sat beside me. Madeline and her Knoxville counsel sat at the plaintiff's table. Judge Trask took the bench at 10. The hearing began with the standard motion sequence. Madeline's counsel argued the cabin was non-compliant. He presented Madeline's photographs of the cabin from her Lot 8 deck. He cited 2 international residential code sections he believed the cabin violated. He concluded his opening at 10:28. Judge Trask turned to my counsel. Tobias stood. He said, "Your Honor, may my client introduce himself for the record before I present?" Judge Trask raised an eyebrow. She granted the motion. I stood. I walked to the lectern. I removed my International Code Council certification card from my breast pocket. I held it at chest height, where the judge and the plaintiff's table could see. I said, in my standard inspector voice, "Your Honor, my name is Easton Whitlow. I am the senior building inspector for Cock County, Tennessee. I have held the senior position since 2008. I personally permitted the cabin at 1187 Stinking Creek Road that same year. I have, at this office's direction, dismissed 11 separate code complaints filed by the plaintiff against my cabin between June of 2020 and February of 2024. My deputy Halsey Brewster has filed an independent compliance report on the cabin, which is Exhibit Defense 3 in this proceeding. The plaintiff has, to my knowledge, never identified me as the county official who signed her 11 dismissal letters. I am informing the court of these facts on the record now. The color went out of Madeline's face from the inside. The Knoxville attorney beside her went pale. The 2 HOA board members in matching down jackets stared. Donovan put his head in his hands. Judge Trask wrote a single note on her bench pad. Judge Trask looked up. Judge Trask said in her measured East Tennessee voice, "Counsel for the plaintiff, did your firm perform a basic public records check on the senior building inspector of this county before you filed this complaint?" The Knoxville attorney did not answer. Judge Trask said, "Counsel, answer the question." The attorney said, in a voice I could barely hear from the defendant's table, "Your Honor, we did not." Judge Trask wrote a second note. Judge Trask said, "Plaintiff's counsel, I am going to give you 10 minutes to confer with your client. The court will recess until 10:45. The civil suit Madeline had filed against my cabin was dismissed by Judge Trask on the 12th of April. The dismissal was issued with prejudice. The dismissal order was 3 pages. The dismissal order found that the cabin had been fully permitted in 2008, had been confirmed compliant by a county inspector in 2024, and that the plaintiff's claims were without merit and apparently filed with knowledge of the lack of merit, given the 11 prior complaint dismissals issued by the county over the past 4 years. Judge Trask awarded me $48,000 in attorney's fees and costs under Tennessee Rule of Civil Procedure 11. The fees were paid by Madeline personally within 30 days, drawn from the Hatch household account. The Knoxville law firm, Lockhart Penrose Stratton, withdrew its representation of Madeline on the 13th of April and filed a small malpractice notice with their carrier the same week. The firm had not, by their own admission, performed the basic due diligence that would have caught my professional role before they filed the complaint. Madeline's removal from the HOA board of Mountain Vista Estates was put to a special vote on the 3rd of May. The vote was 32-4. Aldina Halverson, the original retired UT Knoxville accounting professor who had stepped down in 2022, accepted the interim presidency on the 8th of May. She and her husband Magnus drove over to my cabin the following Saturday morning with a casserole and a handwritten apology from the new board. They sat on my porch for 3 hours. They formally apologized for the previous board's failure to address Madeline's behavior. They told me, in plain East Tennessee, that they had been waiting 4 years for someone to make Madeline stop. Aldina had not, by her own admission, ever known my professional role until the lawsuit hearing. She had assumed I was simply a quiet Stinking Creek Road resident who built nice cabins. She had laughed at her own assumption for 30 seconds. She had said, in her measured Tennessee drawl, "Easton, the whole HOA thinks the county inspector is some bureaucrat in a cheap suit. We did not know our nice neighbor was him. We are very, very sorry. We will not make the same mistake again." Donovan Hatch was indicted by federal grand jury in the Eastern District of Tennessee on the 18th of November. The indictment named him and Cassius Lockhart on federal mail fraud, federal wire fraud, and federal conspiracy counts relating to the cash payment scheme to evade county permitting requirements. The indictment also named 2 of Donovan's bank colleagues on related counts. Donovan took a federal plea on the 3rd of February. 24 months, federal custody at the federal prison camp in Montgomery, Alabama. 3 years, federal probation. $640,000 in restitution to Cocke County for unpaid permitting fees and to the federal government for tax fraud restitution. Cassius Lockhart took a state plea. 18 months, Tennessee state custody. 2 of Donovan's bank colleagues took plea deals ranging from 12 to 18 months. Madeline was not indicted on the federal counts. She had been a passive participant. She had encouraged the unpermitted work, but had not directly handled the payment scheme. The federal grand jury declined to indict her. The Cocke County prosecutor charged her with 3 counts of state-level conspiracy to evade building permits and 3 counts of obstructing a county building official. She took a state plea in March. 6 months Tennessee state custody, 3 years probation, $48,000 in restitution to Cocke County, a permanent ban from serving on any Tennessee community board. She reported to the Tennessee Prison for Women in Nashville on the 8th of April. She has not made a public statement. The Mountain Vista Estates HOA, under Aldina Halverson's leadership, has now adopted a new formal protocol requiring all renovation work in the development to be properly permitted under Cocke County rules before commencement. The protocol was drafted by Aldina with input from my office. The protocol is now the model standard, adopted by 12 other East Tennessee HOAs in the past 6 months. The Cocke County Building Department's permit revenue from Mountain Vista Estates alone increased by 43% across the year following the protocol adoption. Aldina has invited Halsey and me to formally present at every quarterly HOA meeting. We have accepted. We attend each meeting. We answer questions. We have, in the past year, become a small extension of the HOA's compliance infrastructure. Aldina jokes that I am her unpaid consultant. I joke that she is my favorite client. The Newport Plain Talk, Cocke County's weekly newspaper, ran a feature on the case in May. The article was written by a 28-year-old Newport native named Annalise Bogus, who had grown up 2 miles down Stinking Creek Road from my grandfather's old farm. Annalise had interviewed me at the cabin for 2 hours on a Saturday afternoon. She had walked the cabin. She had photographed the half-dovetail timber notches. She had photographed the standing seam metal roof. She had photographed Reuben the Hound asleep on the porch. The article ran 2,000 words. The headline read, in plain Newport Plain Talk style, "The Inspector's Cabin." The article was syndicated by the Knoxville News-Sentinel in the Sunday Culture section 2 weeks later. Annalise sent me a handwritten note when the syndication ran. "Easton, thank you for trusting a local reporter with the story. The story belonged to Cock County. I tried to keep it here. Yours, Annalise Bogus." I framed the note. The note hangs above the kitchen window in the cabin, alongside the original 2008 permit certificate Halsey signed on the day the cabin was completed. Harlan finished his sophomore year at UT Knoxville with a 3.7 GPA. He spent the summer working a summer internship at the Cock County Building Department under Halsey's supervision, with the recusal framework I had filed for any of his work, and earned the position outright in the formal hiring committee process. He has been a department junior inspector trainee since the start of his junior fall semester. He is on track to sit for the International Code Council Residential Building Inspector certification immediately after graduation. He has already told me, on the porch one Saturday afternoon in the fall, that he wants to apply for the senior position when I retire. I have told him he will have to earn it through the same process I did. He has told me he will. I believe him. He has my grandfather Reuben's careful hands. He has my father Davis's careful patience. The cabin remains the cabin. The standing seam metal roof at 12/12 pitch is still 12/12. The hand-hewn half-dovetail timber notches are still tight. The basement is still dry. The wraparound porch is still my favorite place in the world to drink a cup of coffee at 6 a.m. on a fall morning. I have replaced 2 minor exterior porch boards across the past 2 years for normal weather wear. I have not added a single unpermitted modification. The cabin's official county compliance file remains, in Halsey's careful continuing assessment, the most thoroughly compliant residential file in Cock County records. I sit on the cabin porch in the evenings now, with a cup of coffee and a 14-year-old hound named Reuben at my feet. Yes, named for my grandfather. And I watch the south fence line as the sun sets behind the Smoky Mountain foothills. The lights of Mountain Vista Estates blink on across the dusk. Lot 8 has been sold to a young Knoxville family. The new owners came over to introduce themselves the weekend they moved in. They brought their 2 children and a tray of brownies. They asked, very politely, if there was anything they should know about the previous owners. I told them the previous owners had taken a different approach to property management. I told them my office would be happy to help with any future permitting questions. They thanked me. They have called the office twice for routine permit guidance in the past 6 months. Halsey has handled both calls. The new family is, by Halsey's quiet assessment, the kind of careful homeowners Mountain Vista needed. If you have ever had a Karen sue the man who reviewed her permits, leave a comment below. Tell me what she tried. Tell me what you did back. I read every one. The stories you send me are the reason I keep telling these. If this one warmed you, hit subscribe so the next one finds you. Next week, we've got a single mother in rural Indiana whose HOA Karen tried to tear down her son's swing set. There is a wedding video the Karen did not know was running. That story is coming Friday. In the meantime, pull your permits. Read your code. The senior inspector at your county courthouse may be your quietest neighbor, and the dismissal letter is signed. A small word about my my ex-wife Linnea, and how she fits in this story. Linnea read about the case in the Knoxville News-Sentinel syndication in May. She called me on a Sunday evening. She had not called me on a Sunday evening in 7 years. She had said, in her careful Tennessee Department of Correction voice, "Easton, I read the article. I am very proud of how you handled it. Our son told me last weekend that he is becoming a building inspector because of you. I want you to know that he made the right choice. I want you to know I am sorry I doubted that you were the right father for him when we divorced. I want you to know I am glad we still share him." I had not been able to speak for almost a minute. Linnea had been quiet on the other end. She had finally said, "Easton, take care of yourself. Take care of him." I had told her I would. We had hung up. Linnea sent Harlan a graduation card the next May with a small handwritten note that read, "Harlan, honor your father's work the way he honored his father's. Mom." Harlan keeps the card in his desk drawer at the cabin office where he works in the summers. The card is, by his own quiet description, the most important piece of paper he owns. Aldina Halverson and her husband Magnus continue to visit the cabin for Sunday afternoon coffee twice a month. Aldina has become, in the careful way Tennessee retirees become friends with their neighbors, a small fixture in my Sunday routine. She brings her own coffee, a particular Knoxville roast she has been drinking for 40 years, and a small tin of her own homemade biscuits. Magnus brings the local political gossip. Reuben the Hound has decided that Aldina is his favorite person and follows her around the porch for the duration of every visit. We have hosted them 18 times since the case closed. The new HOA board has held 3 formal community potlucks at the Mountain Vista Estates Pavilion since Aldina took over. I have attended all 3. Harlan attended the most recent one in October. The HOA welcomed both of us with the kind of careful courtesy Cock County offers to neighbors it has decided to keep. Some communities adjust to their mistakes. Mountain Vista Estates has adjusted. The adjustment has been worth keeping. The new family on Lot 8, the young Knoxville couple with 2 children, invited me to their daughter's 7th birthday party in September. I brought a hand-carved wooden whistle Harlan and I had made together in the workshop. The girl loved the whistle. The family has invited me back for Christmas. I have accepted. The cabin and Lot 8 are now, by every observable measure, the kind of neighbors Cock County small communities should be. Some properties heal. The houses do. The fences do. The walking paths between them do too. Reuben the Hound has taken to walking the south fence line with me on Sunday afternoons in the autumn light. He stops at the corner post my grandfather Reuben set in 1958 and waits for me to catch up. The post is the same. The hound carries the name forward. The fence is the line we tend to cross the generations. Some lines are quiet. The quiet ones last. I have begun teaching Harlan the cabin's annual maintenance routine. The fall chimney sweep, the spring porch board inspection, the seasonal wood stove gasket replacement, the winter ridge cap check. The teaching takes a Saturday in each season. The teaching, by my own quiet estimate, will continue for another 20 years before he can do it without me looking over his shoulder. 20 years is a long apprenticeship. 20 years is also the only honest length for the work. My grandfather Reuben took 15 years to teach me. I took 18 to learn. Harlan will take what he takes. The cabin will wait. The cabin has waited 18 years for the right teacher. The cabin will wait 20 more for the right successor. The work is the kind of work that does not get hurried. The work is the kind of work my grandfather Reuben would have recognized as honest. The work is, in the long-running East Tennessee Whitlow tradition, the only kind of work worth signing your name to. That is the story of the Whitlow cabin.
Folks, this one was about quiet Tennessee building inspector who had been doing this job by the book for 23 years. Madeline Sheffield Hash did not lose because Easton Whitlow was a meaner neighbor. She lost because she had been filing 11 separate code complaints against the cabin of the man who had spent 18 years reading code complaints for a living. And she had never once thought to look at the signature on the bottom of her dismissal letters. The lesson, friends, is that the law lives where you do not expect it. Sometimes the building inspector is the quietest neighbor on the road. Sometimes the quietest neighbor on the road has just been waiting for you to file something serious enough to require his deputy. If you have ever had a Karen sue your home for code violations, leave a comment below and tell me your story. I read everyone. But remind me we're not alone. Hit subscribe so the next one finds you. Next week, a single mother, a swing set, and a wedding video. It's coming Friday.